NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
Okay, let's go ahead and get started. Thank you for joining us for today's webinar, Prior Conviction Impeachment, the Need for Reform. My name is Monica Milton. I'm Counsel for Public Defense and Special Projects here at NACDL, and I am joined by Professor Julia Simon Kerr, from University of Connecticut School of Law, and Professor Anna Roberts from Brooklyn School of Law. And we want to thank Christine Joseph helping us with captioning services. If you do need those services, please enable those using your menu options.
Thanks so much, Monica. And thanks to all of you for coming and being willing to learn about this really important topic. The presentation today is based on a report that Anna and I recently wrote for NACDL on the urgent need for reform in the area of prior conviction impeachment. And so I just want to flag that report as a resource for all of you. It details problems with this form of impeachment that we'll be talking about and offers suggestions for reform in a lot more detail than we'll get into today. Some of you may also have seen a shorter piece that Anna and I wrote for The Champion on the same topic. And we also have recently created a website where you can find links to the report, but also additional resources like a fantastic appellate brief written by Lila Silverstein in Washington State, contesting the introduction of a prior conviction for impeachment, links to articles by members of a coalition that Anna and I founded, the Coalition for Prior Conviction Impeachment Reform, which is a bunch of professors who are all writing about problems in this area, in addition to other resources. So I just wanted to flag that before we begin. So the talk today will tackle briefly several topics that we cover in greater depth in the report. So we'll start with a little bit of history, talking about how do we wind up with this practice of prior conviction impeachment. We'll then turn to the current landscape and get a refresher on how this is working now. And then we will move into talking about why it's problematic and the need for reform. And we will wrap up with some thoughts about what can be done going forward, what you can do right now about this. So without further ado, I will talk a little bit about the history of this practice. So today we think of the basic problem that impeachment doctrine tries to address as differentiating between people who are being truthful and people who are lying. Historically, though, there was a slightly different valence to this area of law. States employed rules of exclusion to limit the testimony that the jury would hear. Many of you may know about these. These were called competency rules, and they prohibited interested parties, including defendants in criminal cases, from testifying. They also applied to people who refused to swear oaths for religious reasons and to people with certain criminal convictions that society deemed particularly dishonorable or infamous crimes. In some states, African Americans, Native Americans, and some other groups were prohibited from testifying based on their racial or ethnic identities using these competency laws. And all of this was not necessarily because rulemakers believed that these people would lie on the witness stand. Instead, it was really a feeling that members of these groups could not be honorable. So it wasn't worth hearing from them, whatever they had to say. At the same time, some states did do impeachment with prior convictions, often focusing on those that were considered infamous. And again, what you see if you read old opinions about this is that the thought was that people who had committed infamous crimes were considered very lacking in honor and integrity. So it was best not to hear from them because of their status making them not worthy of belief. So in the early 20th century, states transitioned exclusively from this competency regime with some impeachment to a regime of impeachment without excluding people from the witness stand. And when they did that, they brought the baggage of the old regime with them, including ideas about which crimes were dishonorable and therefore relevant to impeachment of witnesses. This is just a representative statute that you can see in Washington State when the legislature there and then the court it talked about this transition from competency rules. They wrote, no person shall be excluded as a witness because of the conviction of a crime, but such conviction may be shown for the purposes of affecting the weight of his testimony. So there's a really strong connection between this early idea that we just don't want to hear from people who have certain convictions or certain statuses or certain racial or ethnic identities to a system where we're just going to introduce prior convictions as relevant to credibility. So I would have argued in my work that what we have today is still a system where these evidentiary rules reflect the idea that people who are in some way dishonorable should be treated differently in court. And now Anna will talk a little bit about the current landscape.
All right, it's wonderful to be with you all. Let's dive into that current landscape, starting with the federal rule, which is Rule 609 of the Federal Rules of Evidence. Under that rule, there are two categories of conviction that can be used to impeach a witness. The first one involves felony convictions. Those are supposed to come in only if the judge finds that the relevant balancing test is satisfied. It's a different balancing test depending on what kind of witness we have and what kind of case we're in. But if we think about the category of situation that I suspect is most of interest to those on this call, if we think about witnesses testifying in their own defense in a criminal case, under the federal rule, the judge is only supposed to allow the felony conviction in if they find that the probative value of that conviction outweighs the risk of unfair prejudice. We'll hear a lot more about those two things that are supposed to be balanced in a second, but roughly speaking, in the federal system, the probative value the judge is supposed to look for relates to how useful they think that conviction is on the question of the witness's, quotes, character for truthfulness. On the other side of the scale, unfair prejudice can cover a number of things, but the judge is often looking to see if they think that the jury will misuse the evidence. Second category is any conviction that required proof or admission of a dishonest act or false statement. And there, as you see, the judge under the rule does not have judicial discretion to exclude. To break this category down a little bit, it could be either a felony or misdemeanor conviction. It is a category that the federal drafters wanted to keep narrow. It is not supposed, under their vision, to cover things like theft convictions or robbery convictions. It's supposed to be fairly narrowly construed to the type of conviction that we might think of if we think of perjury, for example. If the judge finds that a conviction falls within that category, then no matter how minuscule they may find the probative value to be, and no matter how vast they might find the risk of unfair prejudice, under the language of the rule, as mentioned, they are not supposed to have the judicial discretion to keep them out. As you see here, the federal rule has been really influential. Many states have some version of it, although there's a lot of state variation. As we'll talk about in a second, almost every state permits on the books prior conviction impeachment. Where they vary, it's often along lines such as the types of conviction that are admissible and whether after a certain period of time there's an absolute or presumptive bar to that evidence coming in, and if so, how long that period of time is. Outside of that central core, there are some states that vary rather more dramatically in their rule. Some of them allow a lot less in, some of them allow a lot more in. We will zoom in now on some of those states of interest. Starting with Hawaii and Kansas. I didn't see anyone in the chat who's from either of those states. If you are here, please chime in at the end on what we need to know beyond what we can find from the case law. But what we find in the rule and in the case law is that these states have determined that if you are testifying in your own defense at a criminal trial, typically you're not supposed to be impeached with your prior conviction, unless you're found to have opened the door. There's a great deal of play here for judges in how they interpret that concept, but certainly if you get up on the stand and talk at length in detail and with emphasis on the extent of your truthfulness and honesty or credibility, the court's liable to find that you have opened the door to this form of impeachment. Now, Montana, I saw a bunch of you on the call, so I assume things are not as rosy as I'm about to suggest the rule says that they are, but at least according to the rule, as regards all types of witnesses, there's not supposed to be prior conviction impeachment, again, unless that witness is found to have opened the door. Again, I look forward to hearing from Montana about what we're missing here. And then at the other end of the spectrum, and this is something I've been researching more recently, some states mandate admission of felony convictions, even if they appear on their face to have no connection to any allegations of dishonesty or untruthfulness. And in fact, a couple of states go further, mandating admission of some or all misdemeanor convictions. That's enough on this topic for now. I'm going to hand back to Julia.
Okay, so now we'll talk about why we need reform in this area. I'm sure you all probably have thoughts, and that's why you're here. But here is our quick take. So the reason that rule makers and legislators, the rule committees, courts most often give for the practice of admitting prior convictions to impeach witnesses is superficially simple and supposedly appealing. Most courts, and you'll find this in some statutes as well, will assert that these convictions tell us something about a witness's propensity for truthfulness. Here's a representative sample quote from a really influential federal piece. And this is a probabilistic claim that we can predict lying based on prior convictions. So the probabilistic rationale for admitting prior convictions as evidence of a propensity for untruthfulness has a lot of flaws, and there are two that I will talk about now. First, as you all are no doubt aware, prior convictions are not necessarily the outcome of a well-functioning criminal legal system, for reasons you are all familiar with. There are systemic inequalities that burden defendants' ability to go to trial in the first place. Pleas may also not relate to conduct on the ground. So if we're using a prior conviction to say, well, this has some probabilistic connection to whether somebody will lie, we would hope that that conviction would at least represent actual conduct, but that is not necessarily the case. In addition, discriminatory law enforcement practices and prosecutorial discretion also contribute to a system in which one defendant may have no prior convictions to be impeached with, while another may, even if they've engaged in similar or identical conduct. And of course, these disparities are heightened along racial lines, which is something Monica will talk more about in a minute. Second flaw I want to bring up now is that even if we were to assume a prior conviction is a reliable indicator of past conduct relating to events on the ground, the notion that we can learn something about a witness's propensity for lying from the mere existence of a previous criminal conviction of any kind is unproved. Personality researchers have put a lot of effort into identifying characteristics or behavior that predicts lying. And to date, there is simply no support in the social science literature for the notion that almost any type of prior conviction would help us predict whether a witness will lie on the witness stand. If we wanted to offer a statistical prediction of a witness's propensity for lying, we would need a highly nuanced set of information, including many of their personality traits. We would need to know complex situational factors, like what they think is the likelihood they'll be detected in a lie, or the likelihood that they'll be believed, and how they have responded in the past to similar situations, very, very similar situations. And we need other information like age or demographic characteristics. So that's what personality researchers have found. They can do better than chance at predicting if someone will lie if they know a lot of very granular information about that person. So this lack of empirical support for a connection between prior convictions and lying on the witness stand is significant because, as you know, judges have to engage in balancing. You just heard that, and we'll talk more about that. And typically they need to find that the probative value outweighs the risk of prejudice before admitting these for the accused in a criminal case. So a final point about problems here is that we have information about what fact finders actually do when they learn about prior convictions because of prior conviction impeachment. And the answer is they do not use them to assess truthfulness. So one really important study by Theodore Eisenberg and Valerie Hans, which you can actually learn more about if you take a look at a supplemental video that she made just to accompany this webinar. So that's, I'm told, accessible. You'll be sent a link to it after the webinar, where she describes her study in more detail. But in this study, they found that juries lower the burden of proof in close cases, making it easier to convict when prior convictions are introduced. They found no difference in how jurors talk about credibility if the defendant had a prior conviction or not. But what they saw is that jurors interpreted the case evidence differently as a result of knowing the defendant's record. So one of their takeaways was that the evidence against a defendant with a prior conviction appears stronger to the jury. So this segues into thinking more broadly about the question of unfair prejudice. And here there are a number of different risks, some of which implicate fundamental constitutional rights, which Anna will talk more about in a moment. But to lay out some of the risks on the other side of the ledger, there's the risk, or we might say the reality, that impeachment with prior convictions deters testimony. This can lead to defendants taking pleas or to defendants not testifying. And jurors can take silence as guilt. And there's another accompanying unit that you'll get access to after this webinar, where John Bloom talks about a study he did of exonerees and the effect he found of impeachment with prior convictions there, which was a silencing effect. There's also the risk that jurors will engage in propensity reasoning. They're, of course, allowed to do propensity reasoning about untruthfulness, But prior conviction impeachment allows jurors to hear that an accused person has committed a past crime, and they may from that conclude the accused has a propensity to commit crimes and is likely to have done what they are charged with in the present case. And this is a forbidden propensity inference, and it really can't be undone by jury instructions. And finally, there's another risk that jurors will convict someone they view as bad, simply a bad person because of their prior convictions. So it's another form of forbidden propensity reasoning. And as I just talked about, empirical data back up the concern that this evidence is used for forbidden purposes rather than to assess credibility. And of course, again, much of the impact of this falls unevenly along racial lines. So this is a good moment to focus squarely on the racial dimensions of the problem with prior conviction impeachment, which Monica will talk about now.
Yeah, thank you, Julia. So one of the major issues that at least we should focus on with, regarding Rule 609 is that it doesn't account for the drastic increase generally in felony convictions since it was created. The size of the criminal legal system has increased exponentially over the course of the last half century. One of the studies that I like to cite to is the University of Georgia study, which is probably one of the most comprehensive more recently, and it estimates that the number of adults with felony conviction has increased from fewer than 2 million people in 1948 to nearly 20 million in 2010. And so the share of American adults living in the community with a felony record, either through prison or probation, has increased 260%. So we're just talking about a large swath of the American population that now has felony convictions, and that has to live under that umbrella, and that supposedly tells us something about their propensity for truth telling. And another important and I think stark statistic is that this, of course, disproportionately falls on African Americans in a substantial way, especially African American adult men who, as according to the same study, 33% of them have a felony conviction. So think of what that means in courtrooms across the country, where over a third of African American adult men have this lingering, and the threat of impeachment means that so many of them cannot or won't testify or are pressured into taking plea deals. And we see this happen, it snowballs because the disproportional conviction rate means that any future involvement with the system, as we know happens, means that also has a snowball effect. And so I really love this map because it's the same study, that University of Georgia study, but it does show us nationally what these prior convictions or these felony records look like by state. And so some of these may come as a surprise to you. The 5 states with the highest number of African Americans with felony convictions, and this accounts for both men and women, were California, Florida, Indiana, Massachusetts, and Washington State. And in each of those, over 20% of African Americans had felonies. And it's so important to think about how these populations are represented in your state compared to how much they are represented in having felony convictions. And of course, these convictions and these statistics are due in large part to the well-documented legacy of mass incarceration, as we all know. Rule 609 also doesn't account for the systemic racism at each point in our criminal legal system. Research has repeatedly shown that racial disparities persist in virtually all aspects of the criminal legal system, from traffic stops to arrests to sentencing. And bias by these system actors leads to disproportionate criminal justice system involvement, especially for Black people. And there's a cyclical effect because prior convictions weigh on future credibility. Contact with law enforcement, particularly with traffic stops, is often the most common interaction people have with the criminal legal system, and it serves as that initial entry point. And as we know, officers stop Black drivers at higher rates than white drivers. And in nearly every jurisdiction, one study found that Black and Hispanic drivers are searched more often than white drivers. And so if at every point in our criminal legal system, we have these disproportionate contacts with law enforcement, then we see that there's that, increased amount of, or disproportionate number of people of color that are entering into the system to begin with. And then of course, there are higher rates of arrests. And one study determined that in various time periods, higher rates of arrest explain between 70 and 80% of Black overrepresentation in prisons. And there's, of course, the racial disparities that exist in prosecutorial decision-making. Prosecutors have total discretion when deciding whether to charge a person. They decide whether to bring charges or pursue felony or misdemeanor charges, whether to offer plea deals. And this discretion leads to significant disparities in how similar conduct might be charged and prosecuted. And so inconsistent charging decisions can place one person on a felony track and one person on a misdemeanor track, but supposedly the underlying conduct tells us something about their propensity for lying. One group of people who tend to be disproportionately people of color are deemed not credible, whereas those who may not be charged as harshly are, that they fall outside of that, that rule. And then we also have the issue of, if a defendant a person of color decides to testify, there is to some degree confirmation of existing stereotypes about people of color. Certainly race on its own has evidentiary value in American courtrooms, in that it tends to prove or disprove something in the American justice system, just as it does in society at large. And so if you have this person of color testifying, it runs the risk that juries may not just infer guilt from the prior conviction, but also confirm this existing stereotype of Black pathological criminality. And we see that in the way that jurors treat Black defendants. In one study measured by all felony sentences in 2018, 2019, and 2020, Black people were 2.7 times more likely to be convicted than white people in each of those years. Indigenous people in those same years range from being 1.5 times to 1.7 times more likely to be convicted than white people. So, and also, of course, I'm sure a lot of you all know how jurors treat people of color, especially if you have an all-white jury. Juries formed from all-white jury pools convict Black defendants 16 percentage points more often than white defendants. And this gap in conviction rates is eliminated when there's at least one Black member of a jury pool. And so ultimately, the mere existence of a felony conviction represents this culmination of numerous events, and each of those events has its own danger of racial bias. And so when we see a conviction, we have to be mindful of what that really means. And we're using these convictions to say someone's not credible, when we have to look at the system itself through which these convictions arise, and look, critically at whether these things tell us anything about credibility and more about the way our system tends to function. So what can be done? One of the main issues that I like to highlight as someone that did a lot of appellate work is, for the trial lawyers, is you have to raise and preserve this issue for appeal, which oftentimes I think tends to go by the wayside. One of the cases that tells us how to preserve this objection is Lucci versus United States, in which the Supreme Court held that to preserve an objection to a trial court's in limine ruling allowing the use of a prior conviction, that the defendant must testify. In Lucci, the defendant moved in limine to preclude the admission of a prior state conviction, and the district court ruled that the conviction was admissible, impeachment evidence, and on appeal, the court unanimously held that the defendant couldn't challenge the in limine ruling because in order to raise and preserve for review a claim of improper impeachment, the defendant has to testify, and the court reasoned that without the defendant's testimony, it would be speculative to assess the potential prejudicial impact of that conviction. And so defendants can't challenge an in limine ruling if they choose not to testify. So the court offered as justification for this holding that trial courts have to know the precise nature of the defendant's testimony to rule on evidentiary questions, including when it weighs the probative value of a prior conviction against its prejudicial effect. However, this information, as the court notes, is unknowable if the defendant doesn't testify, and any possible harm flowing from an in limine ruling is wholly speculative. And the third justification is that without the testimony, almost any error results in automatic reversal. And so the court essentially says that, you don't want to bury an error, and say, I was going to testify, but this rule caused me not to, and you bury automatic reversal, on appeal. So that was the basis, and how your state deals with this case will tell you how you should preserve these issues. And so I just wanted to also highlight some important issue preservation notes that I like to put in these types of presentations, which is make your timely objections. You have to clearly frame the issue for appeal. For example, if the prosecutor is seeking to introduce a prior conviction under a different rule, for example, 404B, and you made your objection, on appeal, you couldn't then argue anything about Rule 609 because you haven't adequately preserved it under the rule that you're objecting it for. And so then you end up in that plain error, which is where dreams go to die, versus a de novo review. And so it's easier to overcome that harmless error argument if you've properly framed it at the trial court level. And I also want to highlight waiver versus forfeiture, and these are also some pitfalls that happen when you are moving quickly and you're trying to make your arguments, is you don't want to lose your ability to seek review. So waiver falls into this category of intentionally relinquishing a known right. So if you, for example, open the door, then you, of course, can't on appeal say, oh, this shouldn't have been introduced. There's invited error. In other words, you seek a particular result, so you can't challenge that on appeal. Be careful with this one, expressing satisfaction. I know a lot of attorneys do this and they say, thank you, Your Honor, which they don't mean at all. But sometimes on appeal, that can be viewed as you are satisfied with the ruling, or saying no objection. That, of course, is extinguishes the error, and courts don't review it at all. And then the other hand, there's forfeiture, which is you fail to raise an issue, you fail to object, or fail to seek a final ruling. So sometimes this has happened where the judge says, I will address it later, and things move quickly, and maybe you don't get that final ruling. Then on appeal, again, you'll be in plain error land. So I did want to highlight those. So to sum up, object and make sure that it's timely, get your final ruling, memorialize off-record discussions. This is really important and really has been really helpful in the past when I did appellate work, was that some attorneys are very, they insist on getting things on the record and memorializing them and doing their post-trial motions and things like that. So I think that will help to the extent that you can make any changes to this practice. And like I said, be careful with inadvertent waiver or forfeiture. Certainly, if you say I'm not testifying, then you forfeit your appeal, your challenge on appeal. And then, of course, state your legal grounds for objection. So make sure you're not in 404B land when you're trying to challenge the admissibility under Rule 609. And so now I'm going to turn it over to Anna, who's going to talk to us more about the balancing test.
Actually, I think that's
Oh, sorry.
me who will talk about the balancing. We've heard about balancing from Anna as well, and the different tests that are in the federal rule and used by states, but there is variation. But many states do have balancing tests that are especially protective for the accused in criminal cases. So I mentioned the federal balancing test, where a judge should only permit the prior conviction to be introduced if the probative value outweighs the risk of unfair prejudice. So arguing the balancing test should be in your favor, because there's an extremely strong argument that prior convictions have low probative value and a very high risk of unfair prejudice. So some of the things to talk about come from the problems we've been describing, and they just need to be translated into the language of the balancing test. So under the risk of unfair prejudice, you can talk about the risk that the defendant will be silenced and not take the stand, and the demonstrable risk that the jury will use the prior conviction for a forbidden purpose and thereby lower the burden of proof. We've also talked about the limited probative value of prior convictions on the question of truthfulness, which is the thing that is being weighed in this balancing test. And centrally, convictions have not been shown to predict untruthfulness, which at least superficially is what they are supposed to do under this rule. That probative value is further minimized by the fact that the government has many other ways to impeach. And this is a really important point for you as defense lawyers as well. So even if we were able to eliminate the possibility of impeachment with prior convictions, that wouldn't change anything about your ability to, or the government's ability to, impeach witnesses with evidence of bias. So if a government witness was testifying as a result of a plea deal, that information could come in to go to the witness's bias with no restrictions, even if it involved mentioning a prior conviction, with no need for this rule. So, one thing to point out is the government has plenty of other ways to impeach witnesses. So, another problem with the balancing test argument is that the rule itself precludes arguing that there is no probative value to prior convictions, because usually in these rules it says, these are probative. But the protective balancing test for defendants suggests courts should err on the side of exclusion when there is a clear and substantiated risk of unfair prejudice. So, you don't have to say there's no probative value, but nonetheless, the probative value is low, and we have studies showing the risk of unfair prejudice. And as you'll see if you go and look at the supplemental materials on our website, judges have at times suggested that probative value is lessened by a few other things, such as where impeachment would deter someone from testifying. So although that's listed on risk of unfair prejudice, it could also influence their conception of probative value. And probative value is lessened where the prior conviction did not involve testimony by the person convicted, is something we've seen in cases. So that's an argument that's available. But I'll now turn it to Anna to talk about some other ways to make arguments in different forms.
Thank you. So sometimes you'll see a provision in your state or your jurisdiction's rule that appears to read mandatory. If a conviction is of X type, the judge must let it in. I want to encourage you to feel that even if that's the situation, the fight is not over. Indeed, it's just beginning. There's several things you can try even in the face of such a provision. First option is to argue for its scope to be as narrow as possible. We've got an example for you of a brief that we think does this extremely well. It's on our website, the link to which I'll give you in a second, and it's from Washington State. It's an appellate brief, and that brief is dealing with a provision from that state's rule that appears to make mandatorily admissible convictions involving dishonesty or false statement. And this brief makes a very effective argument that it should be a narrowly construed category to exclude things like theft convictions or robbery convictions, just as the analogous federal provision does. Strategy number 2 is to argue that, fairly read, that provision may not be mandatory. There are some rules in some of our states that read mandatory but have been interpreted by judges as requiring or perhaps permitting judicial balancing. Next year, I have an article coming out that gives you the details of some of these state rules as written and then as interpreted. Even though it's just in draft form, you can find it linked on our website under the scholarship heading. And third, you can, as always, bring in the Constitution. Of course, that will trump if there is a conflict with a mandatorily written rule. We've got a nice example for you again on our website, a brief from Oregon, arguing that due process requires that despite the mandatory language of the rule, judges balance probative value and the extensive risks of unfair prejudice that this form of evidence can bring. Now, of course, as we pause on the Constitution here, it's important to remember that all sorts of constitutional provisions are available for you to deploy, whether or not we're dealing with a mandatory provision. So let me just say a bit more about that. We're encouraging you all to think about invoking the Constitution more broadly, and it would be more accurate to say constitutions, because we're encouraging you to think about potential state as well as federal arguments. And here we have some room for hope or optimism or a sense of the collective power of this extraordinary group. If we think about Hawaii, what is it that led the Hawaii Supreme Court to ban prior conviction impeachment, generally speaking, as regards those facing criminal charges? Well, it was a defense argument that worked its way up to that court. And it was a due process claim relying on both the federal and state due process protections, and particularly emphasizing the right to testify and how it was meaningless, given the rule as it was being interpreted at that point. You can see various examples of constitutional arguments on our website, examples from Washington, examples from Oregon. The Washington brief, for example, says that it should be constitutionally prohibited to use this tool as against those who are facing criminal charges. What kind of constitutional arguments are out there? Well, there are a bunch. Case law offers support for your deployment potentially of the right to testify, the right to a fair trial, due process. I could go on. Advocates have also invoked the right to put on a defense, the right to an impartial jury. And if we turn for a second to the other side of the coin, you as defense attorney potentially wanting to impeach a government witness with their prior convictions, it's going to be the confrontation clause that is your most powerful constitutional tool in that situation. As you will know well now from listening to Monica, creating a record at the trial level will aid your litigation of arguments, whether they're constitutional or not constitutional, on appeal. I shall at this point hand back to Julia.
Okay, so now we'll talk a little bit about more forward-looking ideas for what to do besides what you all can do as you're on the ground every day. And Anna and I, along with our Coalition for Prior Conviction Impeachment Reform and NACDL, have been engaged in various reform efforts in recent years. And I'll mention two that are particularly noteworthy. One is the Advisory Committee for the Federal Rules recently invited one of our coalition members to speak to them. And they considered a proposal he made to eliminate impeachment with prior convictions for any witness unless they involve dishonesty or false statements. So under the federal rule, that was to get rid of 609A1. Unfortunately, the committee met to discuss the proposal and quickly rejected the notion that such a change was needed. They were skeptical that the rule actually silences defendants in criminal cases, despite a survey that they had been given by Renee Valladares of the Federal Defenders, who is a representative on that committee. So he is actually in the process of collecting more data to try to respond to this skepticism. But the committee seems open to considering a different change, which would be a smaller one, but perhaps significant, which would make the test for admitting prior convictions against defendants in criminal cases a reverse version of 403 balancing. So the conviction would stay out unless the risk of unfair prejudice is substantially outweighed by the probative value. So right now, the word substantially is not in there. So they're thinking about adding it. We don't know when they will consider this, but it will be important to be engaged as they are looking at that, because perhaps, although it looks like a small change, this could include clarification in the advisory committee notes about how this is really supposed to be quite a restrictive balancing test, to the contrary of how it's applied by many courts out there. Okay, and then separately, we've been engaged in an effort to change the rule in Washington State, and we hope to begin a similar effort in Oregon, because their Supreme Court recently suggested that rule change efforts would be the right forum for change rather than judicial intervention. And in our report for NACDL, we offer several different alternatives for how these rules can be reformed, ranging from total reform to more modest changes. I'll just flag a couple of those for you. One rule change we have proposed involves eliminating impeachment with prior convictions entirely, unless the exclusion would violate the defendant's constitutional rights. Most likely that would be the confrontation right, right to put on a defense. And we think that would protect defendants while almost entirely eliminating this practice of prior conviction impeachment. This could also be coupled with a provision like this that would allow for impeachment with evidence that a witness has lied under oath previously. This could be useful in the sense that we do have repeat players who come to court and lie. So this might be a way to tackle corrupt police officers, for example, or experts who give falsified testimony repeatedly. So those are two of the proposals we have in the report. But we do urge you to find out how rule changes can be made in your states, because often it's not too hard to make these proposals. And it's more a question of how to engage effectively with the decision makers. So I'll turn it back over to Anna.
Thank you. So we feel very excited about the momentum that exists, but we can't keep that momentum going unless we engage in additional fruitful collaborations. And we're excited to talk with you all about what might be desirable. A few options that I can offer right now include, if you let us know of cases you're litigating or interested in litigating, we would love to have a conversation with you about whether we might be able to support your efforts with an amicus brief or other assistance. We are extremely grateful to lawyers in both Washington and Oregon in the cases I've mentioned who reached out to us and started those conversations. We can give and we have given presentations to stakeholders who might be interested or ought to be interested in your jurisdiction. For example, Julia and Monica have presented to defenders in Washington State, and Julia has presented to federal defenders. We're also, as Julia mentioned, interested in assisting you with possible rule changes. Once you track down that rule and how it gets amended, and once you stand ready to exercise the levers of change, we stand ready to assist you. And as mentioned, we've been consulting with folks in Washington with an eye to a possible rule change proposal there. We also welcome, and I alluded to this earlier, your stories of what you're seeing or have seen and your ideas of what to try. It's hard for us to get beyond the reported cases, and we're all too aware that the reality on the ground can look rather different. You know, is it, for example, the case that things are relatively better in Kansas, Hawaii, or Montana, or as I suspect, are there all sorts of workarounds that have developed to get past this potentially somewhat pro-defense difference in the rule? So tell us what you're seeing, and also as you start to peruse the website, which I'll give you the link to in a second, tell us what it would be helpful to have on that website. We aim to be of service. We aim with that website primarily to have resources there that will connect and assist those of you doing the extraordinary work that you're doing throughout our nation. So on the topic of the website, let me get that link up for you. Already up are things like relevant articles, briefs, reports, the bios of those extraordinary scholars that we've gathered together in this coalition to try to translate scholarship into change, into more liberation. And here also are our emails. And I hope that both now and in the future, you'll reach out to us with comments, questions, suggestions. And so now I think it will be time for that part of the presentation to be opened up. I'll hand over to whoever's handling that. I can break the ice by answering a question that came through in the Q&A, or I can at least give a start of an answer. It says, does 609 impeachment allow the US attorney to ask whether the defendant was, number one, convicted of a felony generally, or number two, to the particular felony, or number three, to introduce the facts of the prior offense? And is impeachment limited to asking a question instead of introducing records from the prior conviction? There's a lot of variety in the federal system, and I know we have at least some federal litigators on the call, so if I leave things out or get them wrong, feel free to chime in. But best I understand the majority situation in the federal system, you can bring out the fact of, for example, a felony conviction, its date, its name. You're not supposed to go into a ton of the facts. And I think you can bring it out either through questions or through the records. The exception I can think of to when you might be able to bring in the name is if the judge is concerned about the fact that it's identical to or very similar to the crime being charged. There they might, quote, sanitize the conviction by not mentioning its nature. That's the first answer to that question.
I see another question about whether there's concern about whether imposing limits on prior conviction impeachment may conflict with efforts to lift limits on the ability to impeach police officers with their IAD records, or their records of misconduct. And I think that that is a concern and something that we've thought about quite a bit. And I think it's why we propose a different kind of impeachment, which would be impeachment with the evidence of past lying, that would aim to be able to incorporate disciplinary records like that for repeat players. But typically, as you all know, I mean, the police are not getting prior convictions. So I think the system we have isn't set up to address that. And that's one of the problems with it, is that, you know, we're talking about a defendant's past robbery conviction, and we're not able to talk about the fact that the police officer has, you know, serious disciplinary record, including past lying.
I see a question, Julie, about our amicuses, or maybe two questions. Do we submit in state cases, and do we submit only at the appellate level? I think we're very open to considering submissions at any stage at which they would be helpful, and certainly the ones that we've done thus far were in state cases. Although we're continuing to monitor and to weigh in on federal changes, I feel most optimistic about getting real momentum at the state level, and then being able to say, for example, to federal decision makers, look how things are shifting in the states, because they haven't for a while, but if we can get some momentum going there, I think that could shift things at the federal level. So yeah, absolutely, we stand ready to entertain any reasonable or crazy proposals.
Yeah,
I want to
second
also
second that. Yeah. Go ahead.
I want to also add that NACDL also weighs in. We have also weighed in and at the not the Washington State. We did a petition supporting the petition for review. We also did an amicus in Oregon, you know, from NACDL. So that's also an avenue if you do want us to weigh in, that comes through me. So you know, there are opportunities to seek amicus support, and that goes through our committee. They have to approve it, but certainly given that we've weighed in the past, that's helpful. So if you do find an opportunity in your state to this can be state or federal, an opportunity to seek support from both Anna, Julia, and from NACDL. And also we submitted a comment to the Federal Rules Committee supporting that change to add substantially outweighs. So we also weighed in there. So to the extent that there are opportunities, I think you should, you know, seek out multiple avenues of support, certainly from NACDL, and Julia and Anna, of course, are great resources too.
If I can, I see a question that I'd love to talk about very briefly, but California allows impeachment by felonies involving moral turpitude. How does this factor into your research? Unfortunately, it factored very significantly into my research at one time, and I wrote a very long article about the moral turpitude standard. I think that's one of the clearest ways where you can see the connection between all of this and just ideas about who's worthy of listening to in court, and this idea that, you know, certain people are moral turpitude means base, vile, or depraved, and we shouldn't hear from them. And so I find the fact that California does that and Texas has a similar standard to be really regrettable, because those are such strange standards, but also it provides an opening to talk about the history of all of this and try to make change to those particular types of provisions. On the question about empirical studies on the effect of 609 evidence on likelihood of conviction, I think the study we put up in the PowerPoint, the Hans and Eisenberg study, is they have some reference to that in their study, but as the questioner says, it's really hard to isolate for the effect of the prior conviction impeachment on getting a conviction or not, and that's also been a challenge with, you know, what is the effect on plea bargaining, and what is the effect on the defendant not taking a stand. So these are questions that we want to address empirically, but that are really challenging, but we are hoping to have more empirical research to share with you in future.
And I can make a first stab at a question that's coming on the Q&A. Have the panelists or other research looked at any implications of a chilling effect of using criminal convictions to impeach witnesses in civil trials as well? I realize this webinar is geared toward criminal law, so feel free to ignore my question. I think starting out, for sure, our focus within this topic was the use of these convictions against folks facing criminal charges, the use of them at their criminal trials. But our interests are broader. And so here and there, we've thought through and we've talked a bit about the implications of this in civil cases, particularly in those cases that are maybe most resonant to those who care about criminal matters, such as civil rights claims where a plaintiff alleging, for example, police violence is silenced or humiliated or made to seem unworthy in the eyes of the jury by the use of criminal convictions. So if you look at the list of articles that you can find on the website, certainly some of them touch on civil cases, as well as some of them touching on the other side of the coin that I mentioned earlier in criminal cases, the use of these convictions by the defense against government witnesses, also a hugely important and interesting topic. So we're trying to cover all the bases slowly.
There's a question about whether it's or an observation that it's difficult to prove past lying, which I certainly validate. And I think, you know, it's one of the challenges in this area is is that arguing that we shouldn't do prior conviction impeachment makes certain people feel that they won't have any tools left. And so because, that's just such a good proxy, it makes it so easy. We just talk about that. And we don't have to get into proving past lying specifically. But my view is that it should be easier to access disciplinary records for people who are in positions of authority and therefore, prove their past lying. Of course, that's a separate problem. But that also we need to focus on methods of impeachment that are not grounded in, our histories, our history of racism, our antiquated ideas about who's believable and not believable. And so we should be focusing on impeachment with bias. We should be focusing on, did somebody make a contradictory statement, and those kinds of things, which just aren't regulated at all by these rules that we've been talking about.
Somebody asked, it looks like it's Elizabeth, with your review of Fed cases / state materials in general, when there's been a defense favorable in limine ruling, how do the courts treat it when the defendant arguably opens the door to impeachment, i.e. when the prosecution elicits a statement from the defendant that they're not a violent person, but they have a prior felony assault conviction? I've only looked at the concept of opening the door in any detail in looking at the 3 states I mentioned earlier, Hawaii, Kansas, Montana, and there I found the judges were, in my view, very lax in their, or very prosecution friendly in terms of their view on whether the door's been opened. So beyond that, I have not probed that very interesting question.
The limited review I've done at, reading these cases at the Supreme, the state appellate court level, is that would be viewed as an invited error. And so to the extent that you open the door to it, then the courts would probably review that as now you can't challenge it, or it's an invited error, so it's plain error review. So you got the favorable ruling and then something happens later that you open the door, then I think that's the most that I've seen of it, but there's certainly more out there. But I would like to look more into that. I also wanted to say that following this webinar, we will be updating our resources related to this topic area. Given the amount of questions that you all have asked, I think it would be helpful to look at these and be more responsive at a later point. So keep checking back on our website as we update the resources, and we hope to be responsive to some of the concerns that you all have raised, some of the questions you've asked. So ask your questions, and if we can't answer them today, there may be an opportunity down the line to give you a fuller briefing on some of these issues.
If we have time, there is another question about impeaching an alleged victim with facts from her own pre-sentence report. Does that implicate different rules than introducing the fact of the conviction? And yes, is the short answer. I think the judge might have thoughts about how to introduce those facts without bringing in the fact of the conviction. But contradictory prior statements, we have other ways of bringing those in, exceptions to hearsay, et cetera. So it's a good reminder that prior conviction impeachment rules are really saying, let's just have a whole other category of admissible evidence that we're saying is admissible only because we believe in this connection between prior convictions and truthfulness and untruthfulness, but otherwise wouldn't be relevant. Although information contained, things that happened before related to those prior convictions might be relevant in some other way. But that information should travel separately from the fact of the prior conviction introduced to impeach.
Jeffrey asks, how do you define opening the door? Sounds like BS. Since I opened the door to opening the door, I guess I give a quick take. You know, judges in these opinions, and again, I've only looked in detail in Kansas, Hawaii, and Montana, they view this evidence as relevant. If you start talking about your honesty, truthfulness, or credibility, they see you as exploiting the rule and trying to get around the rule, and they're pretty quick and swift if you do anything that could be read as doing that, to say, well, these convictions can come in so that the jury has a fuller picture of this topic that you have chosen to bring up. Is it BS? Well, it's certainly very pro-prosecutorial. I don't disagree with the tenor of your question.
There's another question from another Jeffrey. Since we're under the present rule regime, what thoughts do you have about neutralizing the underlying concept by arguing to the fact finder that such convictions do not reflect on credibility? I mean, my thought is that it's worth trying. I think an argument that there's no relevance is precluded, at least in the federal system, by what Congress said when they wrote the rules, which is that we think prior convictions are relevant, so you all have to accept that. So it depends a little how the rule looks in your jurisdiction, but arguing that there's very minimal probative value on the question of truthfulness or untruthfulness is completely available and is invited because there are these balancing tests. And I think citing some of the studies that we talked about, but trying to turn the tables and say, hey, prosecutor, if you want to bring this in, you need to show that the probative value outweighs the risk of unfair prejudice. So you have to show me something that shows that there is more than minimal probative value. That would be awesome. And I challenge the prosecutors to find anything to support their arguments. Of course, it's hard because judges are used to this and are used to it just accepting that this tells us about truthfulness or untruthfulness. But I think Anna and I and Monica, we found that when we talk to audiences about this, once they start to ask the question, it sticks. And so I do think that just asking the question is important. And then the more it's asked, eventually we might get some progress from that.
Just to echo and endorse, I think you go for it. I mean, even in the federal system, you've got at least one judge, Judge Weinstein, Eastern District of New York, who was contemplating a motion by the defense to impeach a prosecution witness, a bodega owner who had a prior conviction. And Judge Weinstein almost goes there in terms of relevance. There's little or none. So you've got that precedent. I'm going to try and dig up that citation for you and put it in the chat if I can find it quickly enough.
Yeah, so, there's a question about impeaching through prior statements made under oath, not a conviction itself. And again, if we're talking about prior statements that are contradictory, then we don't have to engage with this rule at all. And the only question is, are you meeting the hearsay exception, which you most likely are if they're made under oath. So that shouldn't trigger this rule at all, I would say.
Yeah, David just asked about Washington versus Gates. If I remember correctly, the highest court in Washington declined to take the case. So also with the Oregon one that I mentioned, unsuccessful at the highest court. But if we're looking for some rays of hope, unsuccessful 4-3, with both the majority and the dissent suggesting that the legislature might want to look at that rule. So even with a loss judicially, as you know, you don't know what momentum you might be creating in another branch or another jurisdiction.
I also thought it was interesting in Washington that the government argued that this should go through the rules making process. So perhaps, that's an invitation to those of you there to try to weigh in to the extent that you can. So thank you all for attending, and thank you for all of your questions and engaging. This helps with us developing future programming, developing resources around this issue, and we want to be helpful to you all. So please use our contact information. I just want to remind you all to take our survey, which should be in your email by now, and you can also use our QR code. Again, this helps with our programming. It helps us figure out what's needed and how you interacted with it. So thanks for attending. And like I said, you'll get an email when the recording is ready. And we hope to hear from you all soon with what you're doing in your states.